48 also. And adjourn for the day also.
Item 13, my lord, they sought adjournment last two occasions, so they are seeking tomorrow. Item 13.
Friday also.
Friday.
Also,
Item 13.
PS also, Lordship.
Lordship.
Dealing with the matters also, he is suffering from high fever, Lordship.
Oh,
Only on health condition, Lordship.
okay.
Lordship, actually, I have come for aggression for item 45, Lordship. Actually, I have not given consent, Lordship.
Mention koise PP lordship adjournment.
That was part heard, Lordship.
Earlier
It's a bail order.
Not bail, Lordship. That NDPS case, criminal appeal, that one. Lordship, how it is possible, Lordship? This is not the way, Lordship.
45,
Anyone may engage, Lordship. Or fix the time at 2 p.m. So many requests is already given, Lordship, in earlier time. I think this may be the 8 times or 9 times.
maybe, yes. Next Tuesday.
How it is, today is Thursday, how it, no, Lordship.
Working day এটা video, Monday.
Tuesday di দিব পাৰিম আমাৰ hearing day bench আছে 2 p.m. fix কৰি দিয়ক এবাৰ problem নহয় লordship
2 p.m.
Tuesday, 2 p.m.
On 2 p.m. at Tuesday. On
Lordship,
Tuesday.
why
Yes,
today not possible? So many PP there, na additional PP, Lordship.
But you see, PS Locker has, I think as he has sought adjournment on the ground that he has taken the file. I think this time you won't suffer, I am sure.
No, Lordship,
then-
last time Boshoda engaged and Boshoda promised
We
2
had that
times.
The motion,
Sunday.
earlier motion day,
আজিতো 27 lordship 1st September di
1st
Monday.
September,
1st September
1st September, what is it?
Monday
Monday on motion day. I'll sit till to 5 o'clock.
Tomorrow or day after tomorrow not possible?
already list fixed we have so many cases already fixed.
I'll sit till 5 o'clock, don't worry.
Lordship, kindly give a direction, Lordship.
Yes. No, but you see, when the council is
Everything
well,
happening like
this
this, na?
direction is uncalled for when the council is not well. Because on both sides, when the council is not well, then
That I
disabled
understood,
directions, I
Lord.
never give
Yes.
disabled directions.
But,
On both sides, it's not that on for PP I am saying.
okay, give a direction.
Remind me.
Well,
Ah,
45 to below
13 they are seeing tomorrow.
45 to
huh?
13 tomorrow, my.
one by one
Friday.
RRI Kotle Bhava. Item number 12, learned additional PP Miss N Das has submitted for time, has prayed for adjournment, लिख दिया, has prayed for adjournment, number 12 day, release the matter when do you want? Who is on? Huh?
Friday no, on 2nd September
13 you want tomorrow?
13, my lord, they are seeking tomorrow.
Friday.
Friday দিব লাগিব
Okay.
Friday hearing fixed
13 to AK লিখি দিবা।
My lord,
on 29th August
Friday কৰি দিবা।
29th August
Yes.
My lord, I am appearing for item number 12. Day before yesterday, we filed our Bakalat number, so we need some time to prepare this case.
12 was the time লাগে,
time
to
to
send
go,
time লাগে।
it's on 10th September
As agreed by both the sides, list the
12
matter on 10 কে লিখি দিয়া 12 সেই sentence টো 13 ত লিখি দিয়া যোনটো dictation দিলো date to দি দিয়া Friday 13th is on Friday
29th August
more fine.
14
14 on
একেটা
3rd September
order
15.
same order
on 4th of September
Miss Andas লিখি দিব হা লানা এডিশন
45 and
45 item 45 on 1st September
That's it.
item 48 as
48.
item 48 on hearing it's on 4th September Lordship এটা part had দুইটা part had কৰি দিব লাগে 45 and 48 part had
45 or 40
45 or
Part had matter.
part had matters
same date দিছে নেকি
নাই বেলেগ দিছো দুইটা
anything else
I do.
বেছি তো দিয়া আছে নেকি গম নেকি
দিয়া আছে
Item, in item 34, Lordship, we can mention item 34, Lordship. I have gone through the office, good Lordship, service has been completed upon all the respondent, Lordship. So Lordship may fix it in admission column, Lordship.
item
item 34 হচ্ছে।
34. Sound here, item 34 to sound here. Just a moment. Learned Counsel, Mr.
JM Gogoi,
J.N. Gogoi.
JM Gogoi
J.M. Gogoi is present for the petitioners
petition,
or appellants?
lordship,
Appellant.
appellant,
Ah,
appellant.
the appellant.
Office to dated 25/6 lordship,
And has submitted that service is complete. Office note dated
25/6 lordship,
25/6/2025 reflects that service on all respondents is complete. On all respondents is complete now. Oh, ঠিক আছে. On all respondents from 2 to 7 is complete. All, no?
on.
1 is appearing.
One is file Ukalatnama lordship, but he has not appeared.
Okay, Learned Counsel, Mr. Your name?
One.
M. Hussain is present for respondent number 1.
This matter is admitted for hearing.
Already admitted on substantial question of law. Okay.
Earlier occasion, notice was issued, directed to issue the notice.
Are you sure? Oh, I
Notice-
think so.
notice
Substantial
was
questions of
issued
law has
last
been framed. Yes, formulated. As the records are before us, we have the record, no?
Yes, lordship.
List this matter for hearing.
Available.
Did you not, item number 16. Possible border date.
Hmm?
Item number 16.
এইটো আৰু এবাৰ চেক কৰি দিবাচোন সাৰ্ভিসটো কমপ্লিট হ'ল নাই 34 আছিলে অকমান চেক কৰি দিব দিয়াচোন
এই মীনাক্ষী কি হচ্ছে?
নহলে হেৰিক দি দিব দিয়া মীনাক্ষী
মীনাক্ষী কি হচ্ছে? Item 16.
Item 16. Possible border date.
অফিচ নোট ডেটেড কিমান আছিলে সেইটো
মিন-
এইটো অফিচ নোটত আছে চাই পেলাই তুমি এই হেৰি পাছফালে চাই
আছে নে নাই? পাৰ্ট ফাইলত থাকিব।
সেইটো পাছফালে চাই লওঁ অফিচ নোটটো চাই পেলাই পাছফালে চাৰ্ভিচ চহী হৈ আহিছে নে চেক কৰি দিম যাব
এইটো হিয়াৰিং ইন ইউজুৱেল কোৰ্স।
Yes,
Item number 16. Possible border date.
Learned Counsel, Mr.
Other
Have you taken permission, consent?
consent, no, other consent.
Okay. Order 41, Rule 11, okay. Learned Counsel, Mr. R.L. Sutia has prayed for adjournment. When do you want? 2 weeks.
2 weeks.
List the matter after 2 weeks.
May I please Lordship? Item 2 Lordship, adjournment for today Lordship, a week Lordship.
Learned Counsel, Miss
J. Akhtar,
J. Akhtar has prayed for adjournment. List the matter after 2 weeks.
week Lordship.
1 week. 1 week. Hmm.
Content taken of the respondent has, I guess, it's an item number 27. Yes, I mean, possible border.
Learned Counsel, Mr.
P. Devi.
G.
P. Devi.
B. Devi on behalf of 27.
27.
On behalf of whom? Learned Counsel, Mr. A.C. Sharma has requested to pass over this matter for the day. মানে লিখিলে হৈ যাব।
Notice 28 also. Item 28.
28 also.
5,000
Same. Okay.
My lord, item 12 kindly fix 8 September.
12.
September.
Kindly fix it.
আবার দিয়া আছে।
Okay, 8 September.
And ma'am, my lord, kindly give a direction to remove previous advocate name from this record. We have Wakalatnama and
What?
previous advocate name from the record.
No. On that day I'll give.
Okay.
Only for adjournment today, next day. You have submitted Wakalatnama, let it.
Yes, I have just day before yesterday we have submitted.
On that day, we will
Oblige, my lord.
pass this order.
May I please, my lord, I beg to mention item number 25, my lord. This matter, my lord, service is complete, my lord. The matter is admitted for hearing, my lord. Maybe fix on hearing, my lord. Kindly see office note dated 31/7/2025. Service is complete. LCR has been received.
M. Hussain, no?
M. Hussain,
Learned Counsel Mr. M. Hussain is present on behalf of the appellants. no?
appellant.
Appellants. Of Lawazima Court's order.
Yes.
Lawazima Court's order dated 15/7/2025 indicates that Notice has been served to respondent number 2. Full stop.
Respondent number 1 to 10 appear, my lord. Respondent number 2 newly Wakalat number filed, my lord.
Who is also represented by learned counsel Mr. J.B. Butcher. Along with respondent number 1 and 3 to respondent number 10. And Wakalat Nama will be submitted on their behalf. You have 10 respondents?
I am for appellant, my lord.
Huh? Oh, you have added 10 respondents?
Yes, my lord, and my lord, 2 pro forma respondent is there, my lord, but the respondent is struck out.
Already struck out?
Already struck out.
Where is the order?
My lord, order dated 1/6/2022 in RS, my lord. Respondent number 7 and 8.
Okay. As the records are before us,
Yes, my lord. Records
Admitted
has been
early?
received. Records has been received, my lord.
yes, record ahija, no? It has been admitted earlier.
Yes,
Earlier it has been
Yes.
admitted. When? Which date?
my
Do you
lord,
remember?
order dated 18/1/2022. 18/1/2022.
This is matter for, as the records are before us, this is matter for hearing.
Most of the
Item 1.
It's an appeal against an award where deceased injured was traveling in a scooty in a drunken state, and he hit his Innova car. And Lordship, as per page 5 of the appeal memo, there is a clear finding regarding admission. Page 5 of the appeal memo.
Page 5 of the
Appeal memo. Judgment, internal page judgment.
can be admitted, you'll pay the.
We'll deposit 50%, not to release those.
Hmm?
We'll deposit 50% of the award before this registry,
Hmm.
and that should be released at this stage.
No. That will decide later.
That will be decided later.
Yes.
They would have to file application.
Yes. Learned counsel, Mr. S.K. Goswami is present for the appellant, former insurer, who is aggrieved by the judgment and order dated, the judgment and award dated 26/3/2025, passed by the learned member motor accident claims tribunal number 1, MSCT number 1, Kamrup Metro, in connection with MSC case number 2146/2021. As the claimant does not deserve and is not entitled to the compensation. The reason being the driver was in a drunken state when the accident took place, full stop. This much or anything more than that?
No. Lordship may admit this petition, call for the records to a rule, and in this stay petition, Lordship may stay this out subject to deposit of 50%. In the appeal, Lordship can admit this appeal, issue notice to the respondents, and the
It will admit issue notice to the respondents. Returnable within 4 weeks.
call for the records.
Call for the trial court records, list accordingly. Ekini first paragraph to I8 likhi diba. Applicant, appellant stroke applicant. first paragraph to লিখে দিবা learned counsel Mr. IA to first paragraph to লিখে দিবা where's your prayer in the
Lordship may record, Lordship
Application?
appeal is already admitted, state subject to deposit of 50% of the award before the registry.
okay your prayer in the application is
Item number 2780.
it is further submitted that on the premises, the applicant has prayed to stay the operation of the impugned judgment and award dated 26/3/2025. Full stop. Considering the submission, considering the submission, the operation of the impugned judgment and order dated 26/3/2025 passed by the learned member MSCT number 1 Kamrup in connection with MSC case number 2146 of 2021 is stayed until further orders subject to the condition that the applicant deposits 50% of the compensation amount within 2 months, no?
Within 4 weeks.
Within 4 weeks from the date of this order.
Applies.
List
Item 6
accordingly.
also, item 6 also same accident, same arising out of same accident.
Dispose করবো by further orders লিখা আছে না? By disposition.
Item 6 also same accident, arising out of same accident, same
Yes,
accident.
sir, দিয়ে।
Same order may pass. Same order. Same accident.
And same. এটা
Same.
item 6 same order লিখে দিন।
Stay petition also same loss. You will deposit 50%,
Stay হয়ে IA
subject to deposit of.
খালি
Obliged.
number খিনি বলে যাও। কিন্তু কেস নাম্বারটো একে আগে দেই। ট্রাইব্যুনাল নাম্বারটো একে।
Obliges.
Item 3,
Statutory appeal, Lordship, filed by the claimant appellant hearing. So my notice may go at this stage, LCR may be called for.
You are for the claimant?
Yes, appellant.
Learned counsel, Mr.
KK Datta.
KK Doctor is present on behalf of the appellant. Stop. Appellant to take steps to issue notice to the respondent returnable within 4 weeks.
So
Call for the trial court records. List accordingly.
LCR may be called for.
Yes, go.
Applies.
item 4,
My lord, this appeal is against the order and judgment passed by the learned MSC Tribunal, Kajalgaon, Chirang district, my lord.
Mm.
There, our main contention is that the lesser amount has been given as an award. Firstly, my lord, the deceased was the plumber was earning 15,000, but his earning has been calculated only 6,000 instead of 15,000. Then next consideration is that wrong appreciation of the loss of earning and future prospects. Number 3, lesser amount awarded under the head of the loss of dependency. There are several dependencies. Then another 4, awarded lesser compensation under the head of the loss of consortium and loss of state. Because your lordship knows, in a case of Magma Insurance Company, Supreme Court has given that each of the deceased member will get the consortium, not only one.
Yes, yes.
Yes. So, my lord, that is one. And another one, my medical expenses are huge, has not been considered. Only minimum money has been and awarded lesser amount under the head of the funeral and traveling expenses that I have spent to take the person to the hospital.
Notice and call for the trial court record.
Yes, yes, and admit it, madam, kindly.
Yes,
No
admit,
problem.
definitely. Agogita admit likhila na appeal to? Admit likhiba, MSC appeal to, admit likhiba. Learned counsel, Mr. S.A. Biswas is present for the appellants who are aggrieved by the judgment and order dated
Dated 30th of May 2025.
30 May 2025 in connection
In
with
MSC case number, my lord,
death, within bracket death case number
26 of 2022.
2022 passed by the learned member MSCT Chirang Kajalgaon. But the appellant to take steps to admit, appellant to take steps to issue notice to the respondents, returnable within 4 weeks.
Notice by registered post.
As respondents by registered post, will be by registered post returnable within 4 weeks. Call for the trial court records, list accordingly.
Item number 5.
Lordship. Here we have challenged this award Lordship of MHT Gwalpara Lordship dated 18/6/25. Your appellant is the insurance company Lordship, and liability has been set in against us Lordship. And here the grounds of appeal is that Lordship, few vital
You are
aspects.
insurer?
I'm the insurance.
Okay.
Lordship.
If you
I'm the-
deposit, then 50%, you don't have to mention the grounds. I'll just straight away
Lordship.
stay and then
Lordship.
we'll issue notice, huh?
Lordship.
Only a short one, in one short line, you can explain why are you aggrieved by the order?
Lordship, it's a case of double benefit. 2 lakhs, rupees 2 lakhs was received by the claimant
Hmm.
from the owner of vehicle. That was not deducted. The multiplier should have been 14 instead of 13 because he was above 45 years. These are two main grounds here, Lordship, we have taken. And there is on contradiction also, Lordship, that owner and driver had adduced evidence in our favor that there was no accident. That aspect was also not discussed, Lordship.
Learned counsel, Mr.
PJ Burman.
PJ Bormon is present for the appellant, comma insurer, who has filed appellant stroke applicant, huh? Yeah. Who has filed this application. Being agreed by the judgment and order dated 18/6/2025 passed by the learned member MSCT Gwalpara in MSC case number 219 of 2018. It is submitted that the applicant has a good case, applicant has a good case as the evidence of the driver and who?
Driver and owner.
Driver and owner.
Driver and owner has
The offending
deduced
vehicle was in
evidence.
favor of the applicant, full stop. Where is the prayer?
Lordship. In the grounds of it.
No. In that application,
Say,
okay,
Lordship.
I've got it. The applicant has also prayed to stay and suspend the operation of the impugned judgment and award dated 18/6/2025 in connection with MSC case number 219 of 2018. Full stop. I've considered the submission on behalf of the applicant, full stop, considering all aspects, the impugned judgment and award date, the operation leader, the operation of the impugned judgment and award dated 18/6/2025 is stayed subject to the condition that the applicant deposits 50% of the awarded amount within 4 weeks from the date of this order.
Dispose of it.
I disposed of. Aru appeal to applicant nilikhibla appeal likhidiba. First paragraph to. First paragraph into application of first paragraph to appeal to likhidiba. Also likhidiba admit likhidiba. Appellant to take steps to issue notice to the respondent returnable within 4 weeks. As usual process.
Lordship.
As
On
per-
register post, we'll take register post.
As by registered post, with acknowledgement, by registered post with AD লিখিলেও হৈ যাব, returnable within 4 weeks, list accordingly. Call for trial court records, list accordingly.
They may be disposed, they already disposed. There is a state application also.
Disposed.
Lordship, similar order may be passed in item number 7 also.
Same,
No, not same accident, Lordship. Same insurance company,
But,
in
that,
here only quantum, Lordship.
that grievance is different, no?
Different grievance. That is only for quantum, that is dispute of medical
Again,
documents.
First paragraph, বাকি কিটা নিচিনা grievance to খালি এটো লিখি দিবা যে is aggrieved as aggrieved by the quantum of the compensation.
Yes, Lordship.
Application to তেনেকে লিখি দিলে হয় aggrieved by the quantum মানে grievance to ইমানে এই আগৰটো নিচিনা driver and owner has given evidence এটো নিলিখিবা
They are only,
এতিয়া
Lordship,
বুজি পাইছা তো
they are only quantum, some medical documents were disputed
Mm.
and this only.
As the medical documents have been
Yeah.
on the quantum of the compensation as the medical documents have been disputed. ইমানখিনি লিখি দিলে হৈ যাব grievance to. That is item number?
Item number 7, your Lordship.
Okay. Okay, I have to dispose.
Aye.
Item 8.
Obliged, Lordship.
Item number
appeal to admit লিখে দিবে।
May it please your lordship. My learned friend appears for the
Respondent, claimant number
File the
one.
vocal. You file the vocal.
I filed the caveat as well as the vocal. Yeah. Copy this.
Their number three. My lord, the,
I.
my lord, the main appeal, my lord. My lord, we have impugned the judgment and award dated 4/6/2025, my lord, passed by the learned member MSCT Kamrup, whereby, my lord, an amount of 48,47,500 was awarded to the, my lord, the claimant. Claimants are mother and brother of the deceased. One of the main facts of the matter is the disease, the family of the deceased, my lord, they are entitled to compassionate family pension, my lord. Because the government of Assam has, my lord, published and notified a gazette notification.
I know.
My lord,
Family pension.
lordship is aware about that. So, my lord, in that case, my lord,
Get equal to his salary, I think, something like that.
full salary is paid till the date of superannuation.
Till the date of supervision.
Yes, and thereafter, my lord,
He'll
whatever
get
the
the
law follows. So my submission before your lordship is that at this
mother
stage,
will get
appeal
the.
be admitted.
Hmm.
My lord, otherwise the coordinate bench has passed orders where only the conventional heads are awarded. There is a direction to pay only the conventional heads. But I don't stick to that because, my lord, here the convention heads are only 84,000. So what I propose is, my lord, if lordship pleases, an amount of a percentage of 20%, my lord, can be directed to be deposited by the insurance company at this stage.
For stay 20% deposited,
20%.
all right.
And that may be.
No, my lord, let them file an application for that. Let them
Somebody
file an
has, huh?
application, we'll file, they are caveators, my lord. Caveators.
Okay.
Respondent 1, 2,
So now at this
One.
stage,
1 and 2.
at this stage, you want only the appeal to be admitted.
Appeal to be admitted in stay application, 20% we will deposit, my lord, 20% of the awarded amount. Release, my lord, we'll let them file an application for withdrawal and, my lord, we'll like to.
Release, yes, you file an application for release. At the moment, I will pass an order for stay subject to deposit of 20%. All right. Ito I to 50%. Ito all beleg, huh? Learned Counsel Mr. R.K. Batra is present for the application. I to present for the appellant stroke applicant who was agreed by the judgment and order dated 4/6/2025 passed by the learned member MSCT Kamrup M in connection with MSC case number 1920 of 2020 awarding a compensation of rupees 48 lakhs,
47,500.
47 lakhs,
48 lakhs, 47,500.
to the respondents who are also related to the deceased, being mother and brother of the deceased.
Mother and brother.
Mother and brother of the deceased, full stop. The insurer, applicant is agreed by the order as the family members of the deceased are receiving family pension being as the deceased was a government employee, state government
He was
employee.
constable.
Full stop. Heard learned counsel, Mr.
Mr. N. Iqbal.
N. Iqbal.
A&E.
A.N. Iqbal for the respondents.
Respondent number 1 and 2.
Respondent number 1 and 2, full stop. The applicant has prayed for stay of the operation of the impugned judgment and award dated 4/6/2025 in connection with MSC case number 1920 of 2020. Full stop. I've considered the submissions at the bar with circumspection. The opt N. Full stop with that. Thereby I deem it appropriate to pass an order for stay of operation of the impugned judgment and award. Full stop. The impugned judgment and award dated 4/6/2025 in connection with MSC case number 1920 of 2020 is stayed until further order, subject to the condition that the applicant deposits and 20% of the awarded amount before the registry of this court. Before the registry of this court. Before নালাগে সব নালাগে এটুক লিখে একটু কামরূপ হয় না before
Before the registry,
before the registry of this court within
6 weeks.
within 6 weeks from the date of this order. In terms of the above observation, this application stands disposed of.
My lord,
এটু caveat to লিখি দিয়া caveat both
Yeah.
parties are present, caveat is discharged লিখি দিবা.
so I am required to take steps on, my lord, respondent 3 and 4 in the main appeal, my lord.
In the main appeal, yes. এটু first paragraph to লিখি দিবা. Learned counsel Mr. R.K. Bhatta is present for the applicant. তাৰপিছত appellant লিখি দিবা, বাকি সেই grievance to লিখি দিবা, লিখি পেলাই তেওঁৰ Mr. A.M. Iqbal is present for the respondent number, which
1 and 2.
1 and 2, full stop. The the learned counsel for the respondents has accepted notice on behalf of the respondent number 1 and 2, and thus no formal notice is required to be issued. Stop. Extra copies to be furnished. Stop. The admit, admit. Issue notice to the respondent number 3 and 4, returnable within 4 weeks. Call for the trial court records, list accordingly.
My lord, steps by registered post as well as usual.
Trial court records as per through registered post as well as usual process. Registered post with AD, no? As well as usual process.
I'm obliged.
Item 30, item 9.
With your lordship,
Mm.
this case is identical to the just previous case, lordship, and my prayer is also identical. This is was a government employee, so family is entered into compassionate family pension scheme.
Okay.
So, affects
আয়ে টু একে লিখি দিবা, খালি নাম ইনসুরার এডভোকেটের নামটো চেঞ্জ কৰি আর গোস্বামী না
Argus.
আর গোস্বামী লিখি দিলে হৈ যাব। আৰু হেৰি তুমি জাজমেন্ট এণ্ড অৰ্ডাৰ এইটো বিচাৰি পাবা না ইয়াত, পাবা না? কিবা কনফিউজন হলে মোক সুধি দিবা। আয়ে টু তেনেকে লিখি দিবা। 20% you are willing to pay
Yes,
20%?
it is.
And amount to নালাগে লিখিবলৈ ইয়াত।
No, 20%.
Compensation লিখি দিলে হৈ যাব, 20% লিখি। 20% or 50%?
20%.
50%.
Problem.
Item
Prayer and stay also same.
Yes, yes. আয়ে আৰু এইটো এনেকে লিখি দিবা। কিবা কনফিউজন হলে মোক সুধি দিবা, মই ডিক্লেৰেশ্যন দি দিম তেতিয়া।
Problem.
Item 10.
Appeal to admit.
May I please your lordship? Lordship, I'm the, in this appeal, I am the appellant claimant. And lordship, this appeal is for enhancement of the awarded amount against insurance company. Lordship, in this, the award Lordship, tribunal court to pass an award only 91,957. Lordship, claimant was not satisfied with the
I
awarded.
cannot hear you. I cannot hear you properly. Cannot hear you.
Oh. Lordship, MSCT Sunitpur passed an awarded amount of 91,957. And claimant was not satisfied with the awarded amount. Lordship, victim is with serious head injury, and his income was not calculated, and the loss of future prospect was not calculated.
Okay, we'll issue notice.
Lordship,
Learned counsel, Mr. Unique.
Abbas U. Ahmed.
You, Ahmed, is present for the appellant. Full stop. The appellant is aggrieved by the judgment and order dated 21/5/2025, passed by the learned MAC, learned member MACT Sunitpur Tezpur, in connection with MAC case number 90/2020, within bracket I bracket close. The appellant is aggrieved by the quantum of compensation as the victim has sustained severe head injuries, full stop. Admit, issue notice to the respondents through
One and two,
through usual process,
Lordship, usual and register process.
as per usual process, as well as registered post with acknowledgement, returnable within 4 weeks, call for trial court records, list accordingly.
Okay. Item 11.
My pleasure. Appeal is only for lordship enhancement filed by the claimant lordship. At this stage, lordship may issue notice on
You are for the
appellant,
appellant. You are for the claimant.
claimant appellant,
Learned counsel, Mr.
J. Kolkata.
J. Kodita is present for the appellant, who is aggrieved by the compensation awarded by the quantum of compensation awarded by the learned member MACT Nalbari in
Nalbari.
connection with MAC case number 14/2022 within bracket that bracket close. Admit.
Lord.
About to admit likhila. Appeal hole sobota admit likhila. Admit, issue notice to the respondent through registered post as well as registered post with acknowledgement as well as usual process returnable within 4 weeks. Call for the trial court records, list accordingly.
Item
LCS
17.
LCS corporate.
Yes, yes.
Lodge. Oblige.
Item 17.
15.
15, I think
Mentioned by
somebody,
the government additional
government
PP.
advocate came
All has been mentioned by.
and has
additional
submitted that the PP is not well.
Everything 12, 13, 14, 15.
Yes.
Mentioned by additional PP.
was there, but I was not doing informed class. I have well prepared, my lordship, with the 2 bail petition.
15.
One rejected, one.
I'm so sorry, I have given a date because the PP is not well. He's suffering from high fever.
I feel, my lord, third consecutive days they have taken time, my lord. And I am
No,
sitting
but,
here, my lord, right
if
from morning,
you
my
You
lord.
see this PP, the last time PS law court, he has assured that he will place his submission. So I believe him. I think-
Lordship, I am up to your lordship. I am not onto
Speak
that,
to
my
come
lord.
and
My
place his
prayer is that,
submission.
my lord, I was not informed, my lord. Lordship kindly prepone it, my lord, little bit. I'll inform the PP of our phone. 14th side auction human delay.
14 on 3rd September, Wednesday. Coming
Wednesday.
Coming Wednesday.
Coming Wednesday. Short date.
15 to ketia hol?
15 on 4th September, 3rd, 4th. Short
4
date.
September. Very short dates.
Lordship, lordship. My lord, on that day, my lord, I know what to be made, my lord. All right.
Item number 17.
Yeah,
Yes,
please,
yes,
Lord.
yes.
My lord, although it is listed for admission hearing,
Hmm.
but service of notice has not yet been completed.
Okay.
My lord, maybe please will take little time to go through the order, office note 25/6/25. AD card has not been received upon the respondent number 3B, 3C, 3D, 4, 5, 6, 6, 8,
Yes,
7, and 10.
Yes.
So
What to do?
unless the service of notice has been completed, it
One is a little bit problematic. You see, no such person in the address returned to sender. So do you know any other address? Respondent number 3A?
I will contact with the appellant, Your Honor,
Yes,
whether
yes,
any
yes.
alternative
Yes,
place is
yes.
there.
And respondent number 9 also, insufficient address.
My lord, I will contact with the
Yes, yes, yes. Okay then. Learned counsel, Mr.
Mr. B.C. Talukdar.
DC Talukdar. BC Talukdar. Mr.
Yes, ma'am.
BC Talukdar is present for the appellant.
Appellant.
And has submitted that service is not complete. Full stop. Office note dated 25/6/2025 clearly reflects that the postal endorsement is the postal endorsement is that respondent number 2 has passed away. Respondent number 3 was not found in the given address. Respondent number 6G has also passed away, and respondent number 9's apostrophe S address was insufficient. Full stop. Furthermore, ADs, no answer notices have been received with respect to respondent number 3B, C, D, comma, 4, 5, comma, 4, 5, comma, 6A to 6H, and the respondent number 7 and 10 till date. Respondent appellant to take fresh steps to issue notice to the aforementioned respondents through what manner? Registered post? Or
I raised that first, my lord.
through registered post with AD, returnable within 4 weeks. List this matter in the orders column.
Yes, my lord.
List this matter in the orders column.
Obliged.
Item number 18 and 19.
Lordship, this matter will possible for the time being, Lordship.
Okay.
Time being, I have some difficulty because at what time it will be taken up. So let it be passed over for the day, my lord, because I have some other
Engagement.
Yes, let it be passed
Pass over for the day.
because at what time she will be.
Yeah, can you tell me what is the span of time relating to time being?
No, Lordship.
See, she has other engagements also. Pass over for the day.
I'm not very well also, so whole day I have to
Hmm.
wait. My lord.
As agreed by both the sides, this matter is passed over for the day as requested.
Okay, took like a minute.
Item number 20 for orders.
Lordship, kindly see the order dated 17/3/2023. The response number 2 expired, madam, but no steps have been taken with this.
Hmm?
Response number 2 expired, madam, but the appellant has not taken this, madam.
Maybe you'll have to give the address, I think.
No, we have submitted everything, madam.
When was the last order dated?
Lordship, 17/3/2023.
17/3,
2023.
2023.
Perhaps they have not interested further in this matter.
Matter has been stayed, I think. Matter has been stayed, I think.
Yes, madam. That's perfect.
So,
And the LCR, madam, technically receive, madam, but that it should not be. Official file date is the 25th.
so I'll give a pass an order. Everything will be brought on record. Speaking order, I'll pass a speaking order. Learned Counsel, Mr.
Yeah, mobile.
A. Mubarak is present for respondent number 1 to 8, comma, and 18 to 22, full stop. The learned counsel has submitted that the order dated 17/3/2023 clearly reflects that the appellant was directed to take appropriate steps to implead the legal heirs of respondent number 2 who has passed away, full stop. It is submitted that the appellant has not taken any steps since 17/3/2023 to implead the legal heirs of the deceased respondent number 2, full stop. Appellant is directed to take steps positively to implead the legal heirs of respondent to substitute the implead নহয়. য'ত implead লিখিছিলে substitute লিখি দিবা. To substitute the legal heirs of respondent number 2 positively on the next date fixed. It is further submitted that the trial court records have not been received relating to title suit number. We have received the appellate court records.
No.
Title suit number or money suit.
Oh, madam. 86/2020.
TS number 86 of 2006.
6.
Call for the trial court records of TS number Amuka Amuka so and so positively on the next date fixed.
This time, after 16 October,
You want a date?
16 October. Item 21.
তাতে হেৰি to employee substitute positively without failing লিখি দিব। List failing which লিখি দিব without fail, failing which necessary orders may follow.
May I please, Your Lordship, matter may be passed over for the time being.
Time being, okay. Okay.
Item 22.
My lord, LCR has been received, my lord, and I think service is completed. So the matter is ready for hearing.
Okay,
Madam.
we'll fix it for hearing then.
In the usual course, my lord.
Due course.
Let the matter be posted for hearing.
They will fix it for hearing. Both the parties are represented, full stop, as the trial court records, all the trial court records. And the original, we have appellate court record also, no?
My lord.
As the trial court records and the appellate court records are before this court, list this matter for hearing.
Most obliged.
I
Time the did you need?
date কি বলে?
Date na lage?
Uh,
After 2 weeks? List this matter for hearing after 2 weeks.
Item number 23 and 24. Item 23 and 24.
Accommodate থৈ দিলে বেয়া নহ'ব, 11টা 11:30 বজা নাই।
Item 26.
May I please, Your Lordship? That the appeal admitted, my lord, or LCR has already received, my lord. That, my lord, in regard to, my lord, service, my lord, office note 19/5/25, my lord. My lord, says, my lord, the respondent number 1 received, my lord, and 2 has shifted the address, and 3-1, 3-2, 3-3, they are insufficient address. So, my lord, except the number 1, my lord, my friend is appear for 1. 2 and my lord, 3-1, 3-2, 3-3, I will take further steps with sufficient, collecting the sufficient, my lord, address. Some more time may be given because address has to collect.
Okay.
Office note 19/5.
C. Goswami, no?
C. Goswami.
Learned counsel Mr. C. Goswami is present for the appellant, and learned counsel Mr. A. Hussain.
For 1.
A. Hussain is present for respondent number 1. Post of the learned counsel, the respondent has submitted that. Service report. That office note has submitted that office note dated 19/5/2025 indicates that R2, respondent number 2, comma 3-1, 3-2, 3-3. Notices on respondent number 2, 3-1, 3-2, and 3-3 could not be served on account of insufficient address and as respondent number 2 has shifted to another address, full stop. Appellant to take fresh, seen the notice dated, seen the office note dated 19/5/2025. Appellant to take fresh steps to serve the notice on the aforementioned respondent in the proper address. Return
Wouldn't we?
True, registered post.
Well, register post.
In the proper address to register post with AD as well as usual process? No.
Maybe earlier malad that has.
Yes, already
Mm.
been done.
Register
Register
post.
post with AD, returnable within 4 weeks. LCR also call for the RSA, trial court records, as well as the original appellate court records. List after 4 weeks.
I think item 21. 21.
Service number 1 to 4 1 to 5 0. 5. My lord, the service regarding my lord, the response number 1 to 5 is not reflected in the correlation.
Service on respondent number?
Step was taken, but my lord, respondent number 1 to 6, my lord, their service may be deemed to have been completed.
Respondent number 6 and 10 is represented.
On behalf of respondent number 6 to 10.
Yes.
Now I will take instruction with respect to 1 to 5.
1 to
1 to 5.
5.
I may be allowed some time.
Okay. There's no office note relating service of notice.
Yes, ma'am.
No office note.
Office note step was taken, my.
Steps were taken.
Yes, ma'am.
I'm taking.
But nothing is mentioned about taking steps being taken also.
Yes.
Let me check.
My learned friend will receive step, my.
He has received. Okay.
No. I declared on behalf of 6 to 10.
10.
I will accept this on behalf of 6 to 10.
Hmm.
Now I have to take instruction from
Okay.
my line.
Okay.
Then they will appear on behalf of the number 1.
And in the meantime, my lord, I may be allowed to take fresh step also, my lord.
It's not required. I'll take.
Not required.
After taking.
Not required. Let's see. Otherwise, you can take later, you can take fresh steps.
Yes.
Learned counsel Mr. A.M. Borguia is present for the appellant. And learned counsel Mr. S.K. Ghosh is present for the respondent number 6 to 10. And has submitted that he may obtain instructions if he may represent the respondent number 1 to 5.
Yes.
List after 1 week, 2 weeks?
2 weeks,
List after 2 weeks.
because there is, my client is coming on 20.
Okay, 2 weeks then.
And what is item 17, I think I was on the late.
Mhm.
I am suggesting.
Respond number 1.
Obliged.
Order dia holding. 17 SK Ghosh is present for respond number 1. लिख दीजिए.
17 to me, sir.
If I may, my lord.
তাতে এটা sentence add কৰিব লাগে concern Mr. SK Ghosh is present for respondent number 1.
If I may, my lord, item 29, my lord, matter is already admitted. My lord, steps, in regards to steps, we have taken steps.
Mm.
Service on respondent 1 is complete.
Mm.
However, my lord, neither AD card nor postal receipt have been received for respondent number 2. My lord may direct us to take fresh steps upon respondent number 2.
Okay, learned counsel Mr.
G. Imtiaz, my lord.
G
Imtiaz,
on behalf of
A. Iqbal, man.
learned counsel Mr. G. Imtiaz on behalf of learned counsel Mr. A. Iqbal is present for the appellant. To stop.
My lord, may refer to office note
Notice has been
dated,
served to respondent number 1.
office note dated 12/6/2025.
Office note dated 12/6/2025 indicates that notice has been served to respondent number 1 nalage. The office indicate market likhi dia. Office note dated 12/6/2025 indicates that service on respondent report, service of notice on respondent number 2 is awaited. Applicant may take fresh steps to issue notice to respond number 2. Returnable within 4 weeks.
Yes, ma'am.
List accordingly.
Deeply obliged.
Item 30.
I think respondent have appeared. The matter is ready for hearing.
LCR.
Respondent number 1, madam.
Okay.
Other-
Only respond number 1.
Was causally reflected the names of other respondents also.
Yes, from respond number 2 to 4.
Yeah.
Yes. Then we will fix it for hearing then.
Hearing,
We have the records before us.
yes.
Duita record আহিলে নেকি appellate or trial? Learned Counsel Mr. N. Sharma
Answer.
is present for respondent number for the appellant, and Learned Counsel Ms. N. Thakuria is present for respondent number.
NS Thakur.
N.S. Thakuria is present for respondent number 1.
One.
The full stop, the cause list reflects the names of Learned Counsel for respondent number 2 to 4. Pleadings are complete. The trial court record as well as the appellate court records are before us. List this matter for hearing. Should I give it time? 4 weeks, 2 weeks, or you have 23?
As usual. As usual.
List this matter for hearing in its usual course.
Deeply obliged.
Item 31.
May I please, sir, Lordship, kindly pass over the matter for the time being.
Time being?
Yes, sir. Item 32 time being.
31 and 32 time being.
Okay. Yes.
Item 33.
For the respondents. Respondent number? 1.
It is report record timely. 32 to report record.
Here, your lordship, regarding respondent 4's address, we have ascertained the new address because the address which we have put in the memo of appeal, she is not residing there. So we have to take steps in the new address. So
If
some-
Learned Counsel Mr. S. Dutta is present, for the appellant, Learned Counsel Miss G. DL Deca on behalf. Okay, DL Deca. Miss DL Deca is present for respondent number 1. Learned Counsel Mr. S. Dutta for the appellant has submitted that he has obtained the proper address of respondent number 4, and he may take steps to issue notice to respondent number 4 in his or her
her correct address.
in her proper address, full stop. Issue notice to the respondent number 4, returnable on
After
after
3
4
weeks.
weeks, 3 weeks.
4 weeks, 4 weeks.
Returnable after 3 weeks. List accordingly.
Obliged.
Item 35. Item 35.
Dia side yung office notes থাকিছে side play order pass কৰি দিম
We main case. Item 35.
লিখি দিয়া মেইন কেছটো ৰেজিষ্টাৰ হোৱা নাই ন
Main case register হৈছে লক্ষিত ISA 12/2008. 12/2008.
আকৌ এটা হেৰি কন্ডোনেশ্যন অফ ডিলে কাৰণে আছে কেলৈ গোটেইখিনি একেলগে ক্লাব কৰি লিখি দিয়ে the applicant as well as the appellant is not represented today. Grey la club code here. Applicant as well as the applicant is not represented today. Is ne R was on 36 degree. Is not represented today.
Yes, I don't.
List this matter after 2 weeks.
Item 36. 36 to be.
My lord, if I may, my lord, the matter may be passed over for the time being.
Time being?
Yes.
Which may actually I am very important, leaves like to file your objection against the application for substitution of the legal yards of the reference number 1 mile.
Time for filing objection.
And depending on their reference number, that's one of
36.
36. See, we can put on it.
So time being is not required there.
Yes, yes, my lord.
In which matter you want to file objection?
For the confirmation of delay, my lord. That will be. I 3 to 6 pro.
3 to
6 pro.
3864, okay. It I 3864 likhi diba, huh? Learned counsel with Mr.
G Imtiaz, my lord.
36.
G Imtiaz, my lord, on behalf of G Imtiaz, my lord.
G Imtiaz on behalf of
R Borua, my lord.
R Borua, it 3864 likhi, huh? Is present for the appellant, stroke applicant, and learned senior counsel Mr. NC Das, no? Is present for the respondent. Respondent number 2 and 3. For you, okay, assisted by learned counsel Ms. G. Anybody for respondent number 1? No. And comma, and has submitted for time to file objection. List the matter. 2 weeks.
3 weeks, madam.
List the matter after 3 weeks. It 3864. Baki kini list after 3 weeks boli likhi dile ho jao. Both sides are represented. List the matter after 3 weeks. Both sides ni likhiba. Respondent number 2 and heri likhiba. Applicant or respondent number 2 and 3 likhiba. Respondent number 1 aha na etu. Baki kita teneke likhi diba 3864 objection to likhi diba.
Item 37.
Briefly on this.
Please, your lordship. Lordship, steps upon the sole respondent is complete. They've filed their wakalatnama also in this case. Maybe fixed for admission. Not appeared to them.
They filed wakalatnama.
Yes, their name is in the cause list also. 36.
Oh, there he is already here.
Admission are gonna fix.
Learned, both the parties are represented, one each.
Yes,
One, respondent 1, appellant 1.
sole respondent.
So respondent, both the parties are represented as the LC, as the trial court record as well as the appellate court record is before us. List this matter for hearing. After
2 weeks.
usual course, 25, no?
Yes.
2025 in this usual course.
Oblige.
Kiman asli ito?
Into 37. Item 38. Item 38.
Sole respondent. LCR আহিলে নেকি?
Lordship, LCR আহিছে 38
We'll fix it for hearing. Applicant is not represented today. Learned Counsel, Mr. D. Gogoi is present for the respondent. Sole respondent, no? As the trial court record as well as the record of the appellate court of first instance is before us, list this matter for hearing in its usual course.
Visual course. Item 39.
Yeah, blue ground. Which is 3 IA, my lord. One is, my lord, limitation, my lord, 208 this, my lord, and other is abatement and other is substitution, my lord.
Condonation.
Lordship.
I for what?
3 IA.
Condonation of delay.
Delay of 208 this, my lord, due to death of the sole appellant, my lord.
You have any objection? No objection. Where is the cause given?
Paragraph number 4 and 5, my lord.
Learned Counsel, Mr. M. Hussain, no?
A Mubarak.
A. Mubarak is present for the applicant, plaintiff stroke appellant, stroke applicant. Who's Learned Counsel, Mr.
H. Buragohain, Lordship.
H. Buragohain is present for the respondent.
Yes.
This, which one is for condonation? IA 932.
932, Lordship.
932, IA 932. Condonation of delay for substitution.
Substitution.
So substitution, my lord, 935.
Oh, 935.
And abatement, 934.
No, please,
Substitution, my lord.
please,
Nine-
serially, otherwise it will be all in a.
First, my lord,
manner.
932, my lord. 932.
First, I'll take up which one? 932.
932, my lord. Limitation.
Limitation.
Lordship.
There are two petitions for limitation. One is for what?
One is for
932 is for condonation of delay
condonation of delay.
at the for filing of substitution petition, Your Lordship.
For filing of substitution
Lordship.
petition. So this will be the first one.
Lordship.
Then where is the substitution petition?
935, Lord.
935. And the last one?
934 is the setting aside of abatement.
Setting aside abatement.
Setting aside
Abatement, Lordship.
of this automatic
Lordship.
abatement.
Lordship.
All right.
For condoning the delay and
Ah.
abatement is proper, my lord. Thereafter, for substitution.
There had to be one more condonation petition, this application, Your Lordship.
Again,
I think so.
Lordship.
only 3.
No, see, for setting aside of automatic abatement, that case has been
After,
automatic. Are you within the period of limitation?
no, my lord.
Then you'll have to file, I think. One more, just ponder over it. I think there has to be one more petition.
Earlier
Just ponder
occasion,
over
we
it, huh?
have- in the earlier occasion, when we have filed, my lord, 3 petitions, my lord. One is limitation and is substitution and condonation.
First, as soon as that person died,
Lordship.
that lady died,
Lordship.
then it got
If
automatically,
limitation is condoned, my lord. If
Oh.
limitation is condoned, my lord.
that has been condoned already.
No, condonation is here, my lord. 332. 932.
See, if you come in a chronological manner, first then when the lady died, then that case was abated.
Abated.
Then you went beyond the period of limitation.
Lordship.
So for setting aside the automatic abatement, then you will have to file one prayer for limitation, to condone the period of limitation. I think so.
Lordship, because the appellant, appellant died on 22/5/2024, your lordship.
I think so. You ponder over it. Are you in a hurry?
No, my lord.
Then ponder over it. We'll wait for some time.
Please, Lord. So this I have for substitution of legal heir of disease appellant, sole appellant, Lordship, under order 22 rules. Sole appellant expired, Lordship.
Okay.
So application is filed within time, Lordship.
Within
Yep.
time?
Within time,
When did she pass away?
Lordship. Lordship will find date of death and name of legal heir at paragraph 2, page number 4 of my application.
9, 14.
Appellant expired on 19th February and I have filed this application 2nd of April.
2nd of April.
April.
Okay.
Maybe allow, Lordship. Actually, we'll go for hearing.
Council Mr. R. Ali is present. I is present on behalf of the appellant who has filed his appellant stroke applicant who has filed his application under order 22 Rule 3, read with section 151 of the CPC for substitution of the legal heirs of the deceased appellant Abdul Majid Khan. It is submitted that during the pendency of this appeal on 19/12/2025, the appellant Abdul Majid Khan passed away, leaving behind the following legal heirs. Paragraph 2, 1, 1, 1, 2, 1, 3, 1, 4, 5, 1, 5, 1, 6. Paragraph 2, page 4 and 5 of us. Being sons and daughter of the deceased appellant. This application is filed within the period of limitation. Thereby, the prayer for substitution of the legal heirs of the deceased appellant is allowed. The appellant may file and amend it. Cause letter?
Lordship,
Or you want to submit file
direction
something?
may be given to the registry only to incorporate the name of the legal heir. The direction may be given to the registry, Lordship.
Okay. The names of the legal heirs of the deceased appellant may be incorporated.
Since appeal is of 2018, Lordship kindly fix for date for hearing, Lordship. Immediately after
Yes,
Puja
yes,
vacation.
RSA 2018, no.
After Puja vacation, Lordship.
Yes, can be fixed. Such a long pending appeal, that too RSA. And you have obtained stay also, no? No. Stay? Obtained.
Hello.
This is matter, as this appeal is pending for a long period, this is matter. After Puja vacation. Clearly. Fill in the. If you can go again. Heard learned counsel Mr. A. Mubarak for the applicant who has filed his application under order 22 rule 9 within bracket 2 of the CPC with prayer for setting aside the abatement in respect of the deceased, sole appellant, late Roma Mitra, who died on 22/5/2024. Heard Mr. H. Buragoy, no?
Yes.
Learned counsel for the respondent. When was the delay? Any order was passed relating to abatement? No,
No.
automatic
No.
abatement. It is submitted that a petition with prayer for condonation of delay in substituting the legal heirs has been filed. Beyond the period of limitation, as the applicants learned about the learned about as the applicants were not aware that they had to file an application for substitution. To stop when they were informed by their lawyer on 12/3/2025.
5/3.
On 5/3/2025, the applicants, patients learned that they have to file application for substitution. And this resulted in the delay.
The same is filed on 12/3/2025. Same is filed on 12/3/2025.
Okay. And this resulted in the delay. Application for substitution, full stop delay. Heard Mr. H. Buragoy, learned counsel for the respondent, who has raised no objection. Considering the submissions at the bar, the abatement, ABAT of the sole appellant, Roma Srimati Narayan, late Roma Mitra, who died on 22/5/2024 is hereby set aside. In terms of the above order, this application stands disposed of. Then this is
Setting aside that, substitution. 9:30.
Hard Learned Council, Mr. A. Mubarak, who has filed his application under Order 22, Rule 3 of the CPC, with prayer for substitution of the legal heirs of the deceased late Roma Mitra, who died on 22/5/2024, who had during her lifetime preferred the appeal RSA number 78 of 2015 is breaking the Bhari. Heard Mr. H. Bragwai, Learned Counsel for the respondent, who has raised no objection, full stop, on death of Roma Mitra, her legal heirs, namely A2 page 2 one
Paragraph 4.
Huh?
Paragraph 4.
Paragraph
4.
or paragraph 4 namely are substituted. Appellant to file an amended constated, submitted.
Hospital already, yeah.
Okay, amended constated. And then what about this appeal? We will list it.
As usual goes.
We'll list it, this appeal.
Not it.
Okay. This appeal to Likurida, list this appeal in its usual course.
Must.
I'm sorry, I'm very sorry, my lord. Item 38, my lord. I could not come on time, my lord. My name may be recorded, my lord. Item 38.
Hearing in
Item 38, my lord.
Yeah.
My lord, leave the
Counsel, Mr. Who is present for the appellant meeting. Or Tinkham disposal is.
Finding item 31.
My lord, today should come for orders. Our submission got copy.
Lordship, as per office note dated 23/7/25, TCR of both the records has come.
We'll fix it for hearing there.
Yes,
What
Lordship.
hearing are present?
I am for the respondent number 1 and 2 only. There are only 2 respondents, but Lordship, I have collected the copy from online. No service received by the respondent. So they may be directed to
Yes, yes.
serve me a memo of appeal, Lordship.
Yes. Okay. Then we'll list it for hearing or we will keep
Yes,
it for
Lordship.
orders?
Yes, Lordship.
Hearing.
Hearing, Lordship, can it be possible on 27th October, Lordship? After
Can be
vacation.
possible. Can be.
28.
But this is 24.
28, Lordship, it's a hearing date.
But this is a very new appeal, so.
Lordship, service complete and LCR also received. The Lordship may fix it, may not reach also, then we will
Yes,
fix
yes.
it. Lordship.
Learned Counsel Mr. M.U. Mahmood is present for the appellant and Learned Counsel Ms. R. Chaudhary is present for the respondent number 1 and 2.
Yes, Lordship. Only 2 respondents are there.
As both the records of the trial, as both trial court records and the record of the appellate court of the first instance is before us, list this matter for hearing on key October.
28 October.
Okay. Yes.
Finding item 32.
Only Lordship appeal memo may be there.
Oh, yeah, I forgotten.
Yes,
Learned Counsel Ms. R. Chaudhary has
That
submitted.
return I will give.
Okay. Look at the Learned Counsel here. The appellant to furnish copies of the appeal memo to the Learned Counsel to the respondents.
Obliged, Lordship.
Item 32. Finding item 32.
Yeah, what will we do? This is, we have taken steps, but
I think they have not received anything, I think. Let me check.
But I have understood they have refused to accept notice. Someone has refused, others.
Lawazima, we have Lawazima order. Let's see what is in the order. Notice was issued to respondent number 1, 2, and 3 by usual process. 1, 2, and 3, it appears that the process service reports have been received. Perusal of the aforementioned service report reveals that their brother is not at home.
You think that
And the sisters have refused to accept notice on brother's behalf.
we have taken steps.
Huh?
We have taken steps, the documents we do have. Oh, Cecily.
What is this? Acknowledgement. What is this?
We have taken steps, madam, that.
Oh, no, you have taken steps. See, now it is placed before me. Lawazima court has not given any opinion. It is placed before me to.
Then it may be sent to Lazima again regarding service, they will give an opinion. Then it may be listed, or your lordship, if they have
No,
refused.
They have already, Lawazima, in view of the above observations, see, woman has refused.
Refused, it amounts to service.
No, it has to be a man, no, male member.
No, when notice is refused to accept, then it amounts.
It can be anybody, male or woman. Male or female.
No, yeah. Official person definitely went, not a third person. Your person.
Why didn't this Lawazima court has not formed an opinion?
Well, the person, the Jari Karok, who went to serve the notice, he is a person of judiciary. So, if
You give me any law that a woman has refused?
oh, yes, if your lordship on that, I'm not sure.
I know it has to be a male member.
No. So far my knowledge is concerned, when a person has refused to accept the notice,
It is there.
it is
Yes.
amounts to accept
You have a
notice.
point, I'm saying you have a point.
Yes. Then
Will
that
wait for some time. You have a point, I'm saying you have a point.
lordship wants to.
As far as I know, it is served on a female member, then it's not deemed to be served.
Male and female both are there.
But now.
Respondents, there are both male and female.
No, that, see, they have not formed an opinion because both these sisters have refused to accept the notice. Lawazima court, that is what this Lawazima court has noted and sent back. So I'll have to form an opinion.
Lordship may wait for some
We'll
time.
wait for some time. Okay. Now, today or some other day?
They don't say, I leave it to your lordship, what your lordship, I think, in my opinion, notice should be treated as served and case may be
Yes,
fixed
yes.
for admission.
Yes, definitely. When somebody refuses to accept. Have you seen the Lawazima court order?
I have not seen, today I have not seen. I will see, madam. I will see after.
Okay, you can check and then maybe later during the course of the day.
At 2 p.m.
Okay.
Meanwhile, I'll go through the workshop.
Item 41.
Well, 2:30, let it to 2. At 2, I have one case.
2:30, you'll be back. I don't.
No,
think
no,
so.
2, I have fixed one case in court number 18. So at 2:30, it may kindly be taken.
Okay, all right.
Item 41.
This IA is for injunction, Your Lordship. I am the respondent in the second appeal. The case is that I was the plaintiff, Your Lordship, regarding a total plot of land measuring 7 bighas. The suit was of the year 2011. And in my case, as a plaintiff was that I was dispossessed and my cousins entered into the plot. 2011 suit was decreed on 2014. Thereafter, they preferred an appeal. Their appeal was dismissed. They preferred a second appeal. The second appeal was initially lying defective. Thereafter, it was corrected and it was admitted. So from 2014, I have a decree in my favor as regards the entire plot of land. Now, what happened, Your Lordship, recently, there are, as it is a big plot of land, 7 bighas, Your Lordship, there are various trees and bamboo bushes that my father planted at his time, Your Lordship. These trees have grown up. Recently, they have cut one entire bamboo bush and sold it for 40,000 rupees, Your Lordship. We immediately approached the police, but since the civil suit is pending, police has just registered a non-FIR case. I have annexed that as well, Your Lordship. And I am praying for an injunction that they may be restrained from cutting down the trees or selling those trees and bushes during the pendency of the second appeal. The decree is in my favor. The appellate decree is also in my favor. Here is a second appeal, Your Lordship. I am the respondent in the second appeal. This is my limited prayer. They have filed an objection to my injunction also. They have stated that the bamboo bushes that were cut, they have not denied that they have cut. That,
Let us hear them.
Lordship, the injunction at best, since they are not here.
Since they are appearing, we have to hear them, no?
Lordship. Ad interim may be considered, Your Lordship.
No,
Because,
why was it not considered earlier then?
Lordship, they have prayed for filing of this written objection.
They
They
have
have already filed. In their written objection, they
Let
have,
us hear them.
Lordship, but
They have already cut the trees.
Lordship, there are other bamboo bushes as well. I have given in my paragraph 8. I have
If they
given
won't come on the next date, but
ad interim may be
very short date, I'll consider it.
Lordship.
Okay.
That may be
Yes.
recorded then.
Because last date they were there.
Yes, sir. Because they have also filed their objection. In their objection, they have not denied it. They have simply stated they have cut the bamboo bushes for the final rights of the neighbor people. Some neighbors have passed away, so they had to cut. But our contention, they have cut a lot of bamboo trees, bamboo plants, amounting to 40,000, and they have sold it in the market. And if during the pendency of the second appeal, they continue doing this, all the trees and plants will be chopped off.
What is, how big is the area?
7 bighas.
After 2-3 days, we'll
Lordship.
fix a date?
Lordship.
7 bighas.
7 bighas.
Okay. After 2-3 days, we'll fix a
Lordship.
date. Learned Counsel, Mr.
BJ Mukherjee.
BK Mukherjee, no?
BJ Mukherjee.
BJ Mukherjee is present for the applicant. It was which is the IA for
IA
injunction?
1225.
1225 is present for the applicant. The respondents have submitted an objection against the prayer for injunction, but they are not represented today. List this matter positively
3rd September.
On 3rd September to consider the matter. No, list this for consideration, failing which necessary order may be passed. বাকিখিনি এনেই ডেট কৰি দিলে যাব।
Item 42.
Wait, Mr. Lordship. I have for Lordship, strike out the name of the performer respondent number 327. I'm on behalf of respondent number 1 and 2, Lordship. Lordship,
You have any objection?
no, Lordship.
No. Can be struck off at your risk. Which one?
Okay.
Which one?
IA number 1296.
They are not necessary parties.
Lordship.
You are for the appellant.
I'm for the appeal.
Learned Counsel, Mr.
B. Deori. B. Deori.
D. Deori is present for the applicant, stroke appellant, and has filed his application under Order 1, Rule 10-2, read with Section 151 of the CPC to strike off the respondent's number,
Performer respondent number 327. Performer respondent
proforma respondent number
327.
3 to 7 from the array of respondents. Learned Counsel, Mr.
S. Hussain.
S. Hussain is present for the respondent number
1 and 2.
1 and 2. Who start? The learned counsel for the respondent has no objection. The names of the respondent number 3 to 7 is struck off from the, considering the submissions at the bar, the names of the respondents number 3 to 7 is struck off from the array of respondents at the risk of the applicant.
Amended cost title.
Amended applicant to submit amended cost title. Applicant stroke applicant to submit amended.
My humble submission, date may be fixed, Lordship, next date.
For that RSC,
Yes, Lordship.
this has been disposed of.
Yes, Lordship.
So I will IS or RSA to list this matter on when do you want?
Lordship, in the month of last week of September, Lordship.
Okay, last week of September. You want a date?
Yes, Lordship, 23, Lordship.
See, last week we cannot fix date. This will come for orders,
Lordship, hearing, Lordship.
for hearing.
Okay, okay.
Last week will be only fixed for motion, I think. So before or after?
Lordship, then,
After, before or after vacation?
16, Lordship.
Yes, yes. Do come at
16,
orders
Lordship.
column, huh?
September 16, Lordship.
16 September. Okay, 16 September. List this matter on 16 September.
Obliged, Lordship.
Item 43. One petition is filed for death of the defendant number 1. I have no objection that the Lordship may allow and give me the instruction for filing the correct RSA. Because it was not within my knowledge.
The condemnation of delay, IN number? I think
IN number
two,
17
three IS here, huh?
1783.
178.
I am appearing for a legal heirs of performer respondent number 3. The respondent number 3
Petition order 22 rule 10 AM.
for giving information about the death of Pradip Kaur, as performer respondent number 3. He was died on 17/5 to 23, and his notice was served upon him 3/1/25. So it is supposed to notice was served upon the dead person.
It was sent from Justice Service.
Justice Service.
Maybe they were not aware about it.
So
About his
appropriate
death.
order maybe.
Huh?
So appropriate order maybe kindly give. Can we pass?
Wait, in which petition I have to pass an appropriate order? Which petition?
Lordship, he can adduce this persons as necessary parties in this case.
I didn't get your point.
The legal heirs of this respondent number 3,
Huh.
they may be adduce necessary parties in this case.
They may be impleaded as
Impleaded,
parties.
yes, sir.
Respondent number 3.
Respondent number 3 died, and
Died.
his legal heirs filed this petition after expiry of about
1 year maybe? 2 year or 1 year?
more
you
than
said
3 years.
two.
Actually, he died in the year 2023,
23.
17/5/2023. Now, 5, it is 2 years. 2 years.
2 years. About
They have, in spite of receiving the notice through the, that is postal, that did not appear. But then I sent the Justice Service, then it was received by their family and they filed this petition. Now, I have no objection because he is necessary party here.
Yes, yes.
So it may be allowed, my lord.
Can be.
And for R2, respondent 2.
You are for respond.
I'm for he's not a party in this case.
Okay.
The legal heirs.
No,
Petition
legal heirs,
you have
legal
legal
heirs are
heirs.
yet
Yes,
to be
no.
made party. They are yet to be made parties.
So there must be a petition for condemnation of delay also.
Lordship, may I clear?
Huh.
Lordship, impleaded respondent number 3.
Yes.
On service of notices came to the knowledge that there is a death.
Yes.
So that part, RSA most probably their party.
Yes.
RSA already party.
RSA
So they are informing the death. Now your lordship can direct the
I may be directed.
appellate side
I may
to
be
take steps
Take step.
for substitution of respondent number 3 in the RFA.
What is your objection?
My objection is not
You
there.
have any
Read the
objection?
informant. I am just informing the court about the
Okay.
date.
That he has
Yes,
died,
yes.
and that appellant was not aware. That
I was not aware
Oh.
because I served justice service
Hmm.
upon them.
Hmm.
Then they came.
Hmm.
They came with this petition informing that their father and
Father.
Hmm.
Father and
Right.
husband.
husband.
Third learned counsel, Mr. DC Pukon, for the applicants. One appellant?
I am the appellant, only one, but my learned friend, he is also appearing for another respondent.
Perhaps his petition.
In the IA, he is the petitioner.
In the I am the petition.
In the IA, you are a petitioner. Okay, okay.
SK Pudar is appearing for performance defendant number 2. He filed an affidavit supporting the appellant.
Third, Mr. S. Soma. Item number কোনটো হয় এইটো?
43. Your name. Your name.
I am for S. Sharma and Thakuria for S. Sharma.
Third, Mr. N.
N.
Thakuria,
Thakuria.
learned counsel, Mr. Third learned counsel, Mr. N. Thakuria, for learned counsel, Mr. On behalf of learned counsel, Mr. S. Sharma, for the appellant.
I am for petitioner in the IA 1783.
He is respondent number 3.
Respondent number 3.
Respondent number 3.
Legal heirs of respondent number 3.
For the, on behalf of the legal, or for the legal heirs of respondent number 3. Performer respondent number
Performer
3.
respondent.
Performer respondent number 3, late Pradeep Kaur.
Late Pradeep.
Who stop? Heard Mr. DCC Pukon for
the appellant.
For the appellant, comma, learned counsel Mr. SK Poddar for the
Respondent number 2.
respondent number 2 and learned
And
counsel
Gustami for
Mr.
respondent number 1.
and
Gusami.
Gusami for the respondent number 1. Full stop. It is submitted that the respondent number 3, late Pradeep Kaur, was the principal defendant number 1 in title suit in PS number 23/2014. Full stop. The respondent died on passed away on 17/5/2023.
On 17/5/2023.
Leaving behind the legal heirs mentioned herein below. Page 3. তিনি গৰাকী আছে হা।
হয়।
এখানে লিখি দিবা নাম কেইটা সিরিয়ালি লিখি দিবা। It is further submitted in that in the month of March 2025, a notice of the second appeal was served on the wife of the deceased respondent number 3, late Pradeep Kaur. Full stop. Full stop no, comma, despite being informed that Pradeep Kaur had already passed away, full stop. As such, this application has been filed for informing this court the fact that on death of late Pradeep Kaur, he is survived by his legal heirs. I've considered the submissions at the bar with circumspection as the legal heirs of the respondent number 3 is already before this court, comma, steps may be taken to, appellant will take steps may be taken to substitute the legal heirs of respondent number 3. And an amended cost settle may be submitted.
Disqualified. Well, another miscase is also there. It is 1456. 1456.
There is one more I.
It is I. 1456.
In this, I may be allowed to 2 weeks time to file my objection.
Learned Counsel, Ms.
And Goswami for response number 1.
MS?
And Goswami.
N. Goswami for response number 1 has submitted for time to file.
File affidavit.
Submitted for 2 weeks time to file affidavit in opposition. List the matter after 2 weeks. Interim order shall remain in force till the next date of listing. And RSA, you want any order on the RSA?
RSA is already there, my lord, after implement.
Implement and will, it's an order.
And interim may be continued, my lord.
Yes. I think I have dictated. Interim order shall remain in.
Let's see, interim against the dead person also. An injunction against the dead person also.
This is an injunction?
Injunction before the honorable court, yes. So
That
file
that was
objection,
not
we'll take
within
it
the
up.
knowledge.
Yes.
Now it will continue, my lord, because after substitution of this legal error. That was not within
Injunction
my
against a
knowledge.
dead
dead
person.
person, yes, sir.
It is not knowledge, my lord.
Let us
It was not-
delete the last line. Interim order.
Yes.
Which one?
That injunction against a dead person.
Yes.
Let us
No,
delete the
let
last
it
line.
continue, my lord, because it will come again, they will contest, my
So, I admit. There you go, 1456.
that will come.
Against one person or against the other respondents?
Other respondent, because one Boliram Shah, I think, he is.
That injunction order is against. the
Boliram
other
Shah is the
respondent.
main person.
Okay, then you can continue.
Big apology, that was in other court,
Yes, yes.
41. Only my presence, if
41. you think,
presence may be recorded.
Yes, it's okay.
AK Hussain.
All right, man.
I think 32.
Yes, well, I have gone through the office notes.
Yes.
2 and
Now,
3,
your court has not passed any
2
order.
and 3 refused directly. And one has refused, one was not at home, but his own person, brother or sister, someone, they refused to accept the notice. So, my lord,
No,
as-
the sisters have refused.
yes, of the office family. Now, order 5, rule 9,
The order 5, rule 95.
and then service,
very
when service is to be completed, that thing is there, my lord. I am reading, my lord, that is, when service is completed, service is deemed to be sufficient. A valid acknowledgement or receipt signed by the defendant or their agent confirms service. Refusal endorsement. An endorsement on the postal article or summons stating that
Order rule 9, CPC.
Order 5, Rule 9 regarding when service is deemed sufficient. Can say.
Order 5, rule 9.
Yes. Latter part, Lordship would say.
There are so many sub rules in 9. Which one?
The sub rules there.
Which
When,
one should I check?
when service is deemed sufficient.
There is 9, there is 1, 2, 3, 4, 5. Which one? Order 5 rule, there is 1, 2, 3, 4, 5, 9.
Here I am showing in mobile. Let me, yes, I am showing you. Order 5, Rule 9. Yes. Your Lordship would see order 5 rule 9, sub rule 5. When an acknowledgement or any other receipt purporting to be signed by the defendant or his agent is received by the court, or postal article containing the summons is received back by the court with an endorsement purporting to have been made by a postal employee or by any person authorized to take delivery of the postal article containing the summons, or had refused to accept the summons by any other means specified in sub-rule 3, when rendered or transmitted to him, the court issuing the summons shall declare that the summons had been duly served on the defendant. Now, sub-rule 3, what does it say? Kindly see. Sub-rule 3, the service of summons may be made by delivering or transmitting a copy thereof by registered post acknowledgement due addressed to the defendant or his agent empowered to accept the service, or by speed post, or by such courier services as are approved by the High Court or by the court referred to in sub-rule 1, or by any other means of transmission of documents, including fax messages or electronic mail service, provided by the rules made by the High Court. Provided that the service of summons under this sub-rule shall be made at the expenses of the plaintiff.
So
That
we
is
need to
true.
go to the High Court rules now.
Now, High Court rule cannot supersede CPC.
No, it won't supersede, but there is, it has been mentioned specifically, provided by the rules made by the High Court.
And High Court has already made here, from here, it goes like
Lawajima Court.
law in lower court, my lord, in lower court.
Served to a lady,
I
so
know,
that they have sent it back to the court.
I'm saying, my lord, in lower court, your lordship knows well.
No,
there
in
is
lower court, you'll have to serve to the lady.
process server.
Ah,
Now, process server is there. Here, kindly
you'll
see,
have to serve to a.
here the
not lady.
Jarikarak's report, Jarikarak's report has been seen. That means be seen as order officials.
Then I'll pass an order. I'll go through all the rules and then I'll pass an order.
In
If you want-
my opinion, my lord,
Huh.
in my humble opinion,
No,
notice has been duly served upon all respondents.
no, I'll pass an order.
Two has
I'll-
refused directly, so that is,
Yeah, I'll pass an order. I'll pass an order. I'll go through the rules and this.
if you also say, I can also help you by providing High Court rules. I will go through it also.
Yes, of course. Then I can give you a time.
3 or 4 days.
Hmm?
3 or 4 days.
All
time.
right.
On Monday, kindly Monday.
On Monday. List this matter on Monday.
First
to take it.
September.
I will take the pains then.
Oh, that's true. No, I will say, definitely, it is our duty to satisfy the
Yes,
court.
yes, because otherwise I will have to search for the,
Yes.
for everything and then I
That-
have to pass an order.
Of that.
May I please, your lordship? My lord, there is an IA, my lord, 2699 of 2025.
IA for what?
IA for implement of respondent number 1, my lord. Okay. So respondent number 1 earlier was Mahakuma Parishad. Now it has been substituted by Jila Parishad. So in place of Mahakuma Parishad, the name of Jila Parishad is to be.
Because it has become a Jila now.
Yes, Jila now. That's
Yes.
right.
Lordship, that's correct,
Kindly, no?
Lordship. Let's
I am-
correct. Lord.
Only correction of name.
Correction of name. ma'am.
Learned Council
Now-
Minister. IA to लिखिबा एटाई आयो वैसे.
T.U. Laskar.
T. Laskar is present for the applicant who has filed his application for correction of name of respondent number 1 in the connected appeal RSA number 178 of 2013. Heard Learned Council Minister
T.R. Gogoi, Lordship.
C.R. Gogoi, government advocate, no?
Lordship.
Senior government advocate.
Junior government.
Heard government advocate Mr. C.R. Gogoi for the respondent state, no?
Lordship.
For
State.
the respondent state. And full stop. The
Respondent number 2, Lordship.
Huh?
Respondent number 2. I am for the deputy commissioner. Yes, Lordship.
The learned counsel for the respondent has no objection. It is submitted on behalf of the applicant that the respondent number 1 was earlier referred to as Mahokuma Parishad Karimganj, which has become defunct, and the functions of the erstwhile Mahokuma Parishad Karimganj that has since been taken over by Karimganj Jila Parishad. Full stop. Thereby, the name of the respondent number 1 is to be corrected and in typed as Karimganj Jila Parishad in place of Mahokuma Parishad. And wherever the words Karimganj Mahokuma Parishad appears, it can be typed and corrected as Karimganj Jila Parishad.
My lord, and so far the other respondent, private respondent is concerned, my lord, from 4 to 7, my lord. Earlier, my lord, I have taken steps and by the instructions, neither ID card nor answer notice, my lord, received back. So, my lord, that may be treated as deemed served.
In that RSA?
Yes, my lord.
In this petition or in the RSA?
In this RSA.
There is no, it will first we file an amended cost title, then we will come. Applicant to file an amended cost title.
And fresh notice should be go to the Jila Parishad Lordship. As because of earlier it was no cooperation.
Fresh notice may be issued to the Karimganj Jila
Parishad
as respondent number 1. In terms of the above observation, I stands disposed of. Yes.
Obliged.
So, my lord, shall I take steps, my lord?
Yes, yes.
But
you can take steps. Yes.
Obliged.
I have already given an order to take.
My lord.
Lordship.
Huh? No, yeah, main case or steps দিব একো নাই তো নাই ইয়াৰ পৰাই দিব পাৰিব
Item 23 and
Obliged.
24.
Oh, 23, 24 এটা আহিছে নেকি নাই আইয়ে আছে নেকি
23 দুইটা আই আছে 24.
23, 24 both the parties are not represented. 23 none appears for the parties. List the matter on
2 weeks.
List the matter after 2 weeks.
Item number 46 and 47 for hearing.
যোৱা তাৰিখত আছিলে না যোৱা তাৰিখত আছিলে বহুত তিনি মাহৰ
My lord, this is the second appeal, my lord, against the order of the RERA Appellate Tribunal, my lord.
43 and 44, no?
Yeah, 46 and 47.
Oh, 46.
In case of 47, my lord, they have also come up against and that same order. Questions of law have been framed. We have
one only.
In item number 47.
47. Now 46, my lord, this is questions of law at page number 16, my lord. The only limited question is, my lord, that once an application has been filed for getting a completion certificate, whether that will suffice and be a deem approval, even though the documents pertaining to the deem approval have not been submitted. That is the substantial question. Once suppose a building comes up and builder comes up and files an application, please give me the completion certificate. Without annexing all the documents which are required in terms of the act, whether if the municipal corporation does not give a approval within 21 days.
This is 9 of 2025?
No,
April 9 of 2025?
5 of 24, man. 9 of,
9 of 2025 or 1? We have 2 April.
9.
9, okay.
9.
What are you projecting in which order?
My lord, the impugn order.
No. What are you projecting?
Page 16, my lord.
Page 16. Yes.
The application that was filed, my lord, was defective, man.
Oh,
So-
this has not been admitted, no?
No, not admitted, my lord. There was limited.
Oh, okay.
Questions of law may be framed, my lord. Then
Yes.
para number
We can
6.
frame it there.
My lord, the submission which my learned friend is making,
Hmm.
but that factual aspect has been taken care of in the appeal and before the learned trial court. Now only we require is a question of law. Does it raise any question of law? That has to be seen, my lord. Because it's talking about the just application, submission of application for applying the occupancy certificate. That aspect has been taken care of.
So earlier this,
And in second appeal, my lord, the factual aspect cannot be brought before the court.
no.
I'll satisfy my lord. I'm absolutely satisfied, my lord. Absolute question of law, my lord, because
This, you see, already in 1 of 2025, one question of law has been.
yes, that is an independent appeal, my lord. That is not a cross appeal. My appeal is on a different footing, their appeal is on a different thing. My lord, may kindly come up to the order, my lord, which was
No,
passed.
you see, this is the same case, isn't it?
Yes.
That's the same case.
Both parties are appearing, this is a.
No,
court
no.
case. On with two different appeals you are appearing.
Yes, yes.
So this is the same case.
My lord. My lord,
Only you
my,
have taken a different point of view and you have appeared as a appellant here in
in
one.
47, I am the appellant.
And you have appeared as appellant in 9. You are appellant in 9.
Yes, and they are the appellant in one.
Appellant in
One.
Yes.
But it's the same case.
No, my lord. They are aggrieved by the other orders passed by the appellate tribunal. We are aggrieved by other orders. There are some orders passed by the appellate tribunal. Both of them are aggrieved by different orders.
Different types of orders.
Yes. So my case is absolutely different, madam. My case is that whether without filing that application, without filing the documents, whether
Well, one question of law, let us frame and admit it.
My lord, but that
Because
has
this
been.
matter is taken up for hearing together.
Yes, my lords may kindly come to my appeal, my lords, the appeal number 1 of 25. My lord, the question of law frame. My lord, our challenge to the case was that, my lord, there was, the RERA court did not have jurisdiction to try the suit because we have, the learned appellate court had accepted that we don't require to register as we have already received the deemed occupancy certificate, my lord. So that has been admitted and a question of law has been framed. That aspect that we have received the deemed occupancy for which his submissions are there, because that I am applying making the application, the consideration has not been done, but that has been done in the appellate court order itself, my lord. The factual aspect has been taken, the evidence has been led. Now, according to his submission, that again the factual aspect has to come into play, my lord. That it has to be seen that whether I have filed the application or not. That has been filed before the learned authority, my lord, for the receiving the occupancy certificate. My question is like, my lord, that the RERA court did not have jurisdiction to try my case because I have already received the occupancy certificate which the appellate court has approved. And his submission is that I have not applied for the occupancy certificate.
No, that is not my case, my lord. My case is that they have applied, but that application itself is perverse. You just cannot go and file an application, please give me. You have to accompany the entire set of documents. Without that, that is already there, my lord. One more case has come up, my lord, before the bench, wherein the same question has been framed. I can give a reference to that.
Let me see. Otherwise, we can dispose this off together without framing any questions of law.
My lord, that can be done. Question of law has to be framed, my lord. Because
no, my lord, this is not a compulsion, my lord.
Yes.
No, this is not a compulsion, my lord. The section 100 is clear.
Yes.
That when the factual aspect.
Where there is no question of law, we will dismiss it.
Yes, absolutely.
So,
but that has to be framed, my lord.
We cannot take up this appeal together in this manner.
My lord.
I'm telling you why.
My lord.
Here, this question of law has been framed in your case.
Yes, my lord.
Here, we'll either frame the question of law or we'll dismiss it.
My lord.
Yes.
So, we'll have to hear him.
My lord. My lord, may hear him.
But we cannot hear the appeal now.
My lord.
It can be detagged also, my lord. That can be detagged. Only reason for tagging both of them.
We will hear the appeal on another date.
Another date, my lord.
It has to come in a chronology.
My lord, that is there. But it has been tagged along, actually.
Yes, that is why I'm saying. But you see, either I'll dismiss his submission or I'll frame the substantial question of law.
I leave that to your lordship.
Yes.
Because, my lord, what has happened? Municipality.
Page 16, no?
Page 16 is the question of law. My submission is that doctrine of relation back of that 21 days cannot go back, my lord. Reason being that they have to file all the documents along with that application. Now, suppose somebody comes up, just files, "Sir, please give me a completion certificate," without any documents. Even the building has not been started also. Whether that will be a deemed approval, that is the question of law to be decided. That cannot be a deemed approval. That is what the law says. The perversity of the appellate tribunal was that they did not consider it. They say that no, since municipality has issued, we take it as deemed approval. But the issuance of the certificate by the municipality itself is perverse. What they had done, initially they rejected it. And I don't know how it came up. After some time, while filing one and other application by the builder, they approved it. Everything is there on record. So my only question is that let us not go into the facts. The thing is that whether thus filing of an application without the necessary documents, the act which says that 21 days of deemed approval will be applicable or not.
So which part of the judgment you are aggrieved with?
My lord, we are aggrieved with the, my lord may come up.
Paragraph?
They say that
You have framed this substantial question on what?
yes, we have already framed.
Four.
Five.
Which page is the judgment you are?
23, my lord, page 23, 33, 30.
Page 33, okay. Page 33.
Last part, my lord, may come up.
Line, okay. Judgment was by the appellate tribunal.
Appellate tribunal, my lord.
Okay.
Because, my lord, may kindly appreciate at any point of time that cannot be a deemed approval. Somebody comes up, files an application, municipality does not respond, means it is a deemed approval. Now, what in this case municipality has done, municipality subsequently rejected their application. That is also there, my lord, may come up too. And what they have done, my lord, in this case, the fire, the electricity, the lift, everything has been installed after the approval has been given. How come? When the law says you have to submit everything. Just in order to evade that window of that RERA, because if they get that permission before the RERA came into play, they will be not covered under RERA. Just in order to evade that RERA Act, they somehow got that approval. So we say that cannot be. You have to get everything. Suppose there is no electricity in the building. You get approval from JMDA. How? You don't have a lift. You don't have a fire safety equipment. How do you get it? Because the law says you have to have it. Schedule 2 is specific in that. We are on that ground, madam, that you cannot. In that, everybody will, under Malafide, will file something and say that, no, in the 21 days you did not react. It is a deemed approval. It cannot be a deemed approval. All the documents I have annexed, Your Honor. If Your Honor wants to see the facts, I have annexed all the documents. And this is a substantial question of law, whether without filing of all the documents, can that rider of 21 days of deemed approval will apply or not?
At which A? Substantial question A, B.
My lord, I have comprehensively mentioned everything, my lord. Number B is very important, my lord.
See, we will boil down to only the main point.
My lord, no problem.
We won't raise all those questions, formulate all those questions.
No problem, my lord. My only thing is that, my lord, whether that is deemed approval or not. Because the RERA says, appellate tribunal says, will not vex them with 1 lakh penalty since they not cover under RERA. How come you don't cover under RERA? The approval that has been given, my lord, will see. At page 153. Your Honor, got it? You see, Your Honor, the approval date is 5/2/2019.
153?
Yeah, 153.
Overlapping page 19.
Yes, my lord.
Okay.
Approval date is 5/2/2019.
5 to, yes, yes.
Ha.
I have found.
Ha. That is absolutely after that date. RERA as per section 3 says that you need not cover under RERA once you get it registered. That is within 3 months of that commencement.
After 3 months.
Within 3 months. That was in 2017, my lord. Now, my lord, will come up subsequently, we'll see in 171. Page 171. License for lift was given on 4/9/2018.
Okay.
Got it, my lord?
Yes.
Then subsequently in 173, the electricity was given on 3/9/17.
170.
173. Electricity was given on 3/9/17.
So it was after.
After that, my lord. After the RERA came into play.
3/9/17. 3/9/17.
My lord have got it?
173, no.
Just below that
Oh,
word.
yes, I got it, yes.
Below the word normal.
Yes.
Then, my lord, may come up that fire at the next page, my lord. This is a fire certificate, my lord. This is given on 15/11/19, my lord.
Yes, yes.
Now, my lord, may come up to the Assam notified area. In schedule 2, we have specifically taken up that plea, my lord. That cannot happen. Why it is this?
Oh dear. Silo. Oh, library pa luya niba? Joriyat nahi, huh?
Madam, I kindly see.
How will you read?
Huh?
If you're giving.
No, I have that in my appeal memo. I have marked that. Schedule 2, documents to be submitted. Pencil mark you have got.
Schedule 2 documents to be, yes, yes.
You all have got it? I pencil
Yes,
mark.
yes, yes.
Documents to submitted along with the completion certificate. NOC of
mark kori dibason de highlight diba library ba ani pencil di korile hobo nole kitabখন temper kora hobo na library na hiato hon time marker di pencil di korile hobo. Yes, yes, documents, yes.
NOC fire, NOC lift, certificate of installation of DJ.
Yes.
Then
it is there.
Then
the one question will frame them.
Whatever, my lord, the
There
only
was
thing.
question.
Ha.
He has a point. Why should we delay it any further?
My lord, my only submission is, my lord, if your lordship may come.
No,
to the-
you.
My lord, I may not
contest it.
be allowed to submit because the notice has not been issued. I leave that to your lordship.
Okay, you submit then after the break then.
My lord, only one submission, my lord, just
Sure. Okay.
1 minute, my lord.
You're
Okay,
or 1 minute. Or else we can come after the break.
no problem.
If we are extending more than 1 minute, we can come after the break. Or else you can submit and finish it.
Let the question.
I'll just point out one paragraph of the judgment of the appellate court.
Yes.
I'll leave that to your lordship after that.
Yes.
My lord, the paragraph 15. Apna page number in my appeal, my lord.
Your name?
N. Patiri, my lord.
And
Patiri, P-A-T-I-R-I. Well, the paragraph 15, 16 is important. 15, 16, 17.
15, 16 and 17 of the judgment.
17 and 18, my lord.
15, 16, 17 and 18 of the judgment. Yes, you can read it.
My lord. Para 16, I'll read, my lord. In so far as the challenge to the direction number 6 is concerned, the regulatory authority have noted that the real estate project called Bhubaneswar Tower was an ongoing project as on 1/5/2017 and was not in receipt of the occupancy certificate until 5/2/2019. Despite having applied for the same on 29/6/2017 due to shortcomings in the said application. it was noted that registration of the said real estate project under section 3(1) of the Act, read with Rule 4 of Assam Real Estate Rules 2017, was yet to be done. Consequent thereof, the regulatory authority imposed penalty of rupees 1 lakh in terms of section 59, subsection 1 of the Act, with direction to the appellants to register the project with the RERA. Well, the next paragraph, it is submitted on behalf of the appellant's promoter that the grant of occupancy certificate in the present case is governed under Rule 24 of the Assam Notified Urban Areas Building Rules 2014. It is submitted in terms of Rule 24, the Jorhat Municipal Board, after having received the completion certificate from the owners in terms of Rule 23 of the rules, was mandatorily required to inspect the work related to the real estate project and either sanction or refuse an occupancy certificate in the format prescribed under Form 24 or Form 25 of the rules, as the case may be, within the next 21 working days from the date of completion certificate. It is submitted that in presumption legal fiction is hedged in the rule, said Rule 24, to the effect that in the event the occupancy certificate is neither sanctioned nor refused within the next 21 working days, as communicated according to the prescribed formats under Form 24 or 25, then on expiry of the said 21 working days, the project in question shall be deemed to have been approved for occupation by the authority concerned. In this context, it is contended that the application for the occupancy certificate having been applied for on 29/6/2017, and neither any inspection of the project having been done, and neither the grant of occupancy certificate having been sanctioned, nor refused in the prescribed forms 24 or 25, within the 21 days from the date of application, that is 29/6/2017. Therefore, it must be deemed that the Jorhat Municipal Board had approved that the building is fit for occupation. Just such deemed approval as contended having taken place within the window permitted under Section 3 of the RERA Act, that is before 1/8/2017. Therefore, there was no legal necessity for making application to the regulatory authority for registration of the real estate project. As a necessary corollary, as contended, the applicants could not have been held to have violated the provisions of Section 3(1) of the Act and to have imposed any penalty with Section 59 of the Act.
That is the perversity one.
My lord, out here.
I understood that. That is what he's saying.
My lord, that is there, my lord. Because that fact has been taken care of. That is my submission. My lord.
Yes, I understand.
That we have applied for the
I
certificate. They
understand.
were required to do the inspection within 21 days. They didn't do that. And if they have to refuse our project, then there was a specific format under Form 24 and 25 of the building rules. They haven't done that. Then, so we got the deemed occupancy certificate. And that was within the window period of Section 3 under RERA Act. So that thing has been has been approved and accepted by the Learned Appellate Court. The evidence has been, they have taken the plea that this was not done, that we hadn't applied properly. There were some applications, incomplete applications we have filed. But this fact has been taken care of by the trial court, and the appellate court, and the appellate court has rejected this plea. So that is my only submission, my lord. Then what is the purpose of framing any question of law which is based on fact and evidence?
Absolutely not, my lord. The question is that whether without filing the documents, can the deem approval come into play? Somebody comes up, files an application, municipality does not respond, then in that case, every building will come up. That cannot be, that is the law, my lord. That is the question of law to be framed. My lord may see 152, they refused it, but subsequently. In page 152, the municipality refused it. And on the same application, they again granted it. I don't know how this municipality is working. Page 152, the municipality refused the building permit. Now the question is whether without filing that application and without attaching all those documents which is mandatorily required. Now suppose what will be the fate of that building, my lord? If the court says no, let it be a deemed completion. And the builder says no, you go and stay. There is no electricity, no lift, nothing is there. A person comes up, files an application before the municipality says no. Now neither the court can come into play, neither the RERA can come into play. Reason being, the municipality did not respond in 21 days. Can that be a law? Somebody will not even put a single stone, a single brick on that house. How can that be a deemed approval, my lord? No electricity, no lift, nothing is there, no fire. Then let us remove everything from the law itself. Nothing is required. Only one application. 21 days, municipality does not respond, it is a deemed approval. Let this question of law be framed. Let the court answer that, whether this will be a deemed approval or not.
Which one directly answers?
My lord, number B is there. The court, if required, can modulate it. Basically, our grievance is whether without submitting the requisite documents, will it amount to deemed approval if the municipality does not respond? Number B is there, my lord.
That is there, my lord. That's why the municipality has to come and say that your
Not required, my lord.
your,
Absolutely not required.
application is incomplete. But
No,
they
no.
haven't done that.
No.
And this plea was never taken before the trial court.
It was
neither the
taken.
appellate.
It was taken. We
They are
said that.
saying that we received the electricity connection in 2018 November.
Yes.
But admittedly, he came into possession in February 2018. So I don't know how come he was staying without electricity for 6 months.
Maybe.
That
That is a
was
different
always
aspect.
taken
That is
care.
a question of fact, my lord. My thing is that question of law to be decided.
That fact has to be taken care of.
Whether we were in occupation, the question is whether that can be deemed approval.
Does that amount to?
Because they only want to evade that RERA Act, my lord. Only that is the concept. But what was the business of the municipality to come up and give them a certificate subsequent thereof if it was a deemed approval? They do not have a electricity, that is admitted. They do not have a lift. They do not have a fire. And the RERA says that no, it is a deemed approval. How can it be a deemed approval?
I heard the appeal also, but you see, I think this will not be in order if I hear the appeal and.
My lord.
Yes, because
will
question of
come
law
to
will be
this-
framed, my lord, and let that be disposed of. That will be the best one.
I've submitted, my lord. I'll leave to your lordship.
Okay, I'll ponder over it.
My lord. Because if that be so, because I have given one more judgment, my lord, our
I'll look-
coordinate bench, that also same question, whether that will be a deemed approval. Because that is very important and pertinent, my lord. Because what will happen, subsequently every building will come up and say it is a deemed approval.
This is by you, no? For which case number?
Some other
9?
case, my lord, my lord may keep
For
that.
item number 46.
46.
47 has been admitted, my lord. That
Item
has-
number 46 will be
Question of law will be
Uh,
framed if it.
RERA appeal 9 of 2000.
9 of 10. Because this is very vital, my lord, because every time the builder will come up and say that no, since 21 days they did not respond. And the application that they filed also, no, my lord, you'll see the NOC are missing. I can just point out, my lord,
Which page?
page is at page 149.
My lord, can we go into trial in the second appeal? my lord?
No, not trial, just because the court wanted to see into it. Page 149 and 150.
Has this plea taken in before the?
Yes, absolutely.
trial
That is
court?
not taken. That is not a deemed approval. We have taken that plea. And in fact, this answer will help lot many people.
Court goal more hearing argument can লিখি দিছো বলে
Next idea আছে।
হ্যাঁ মানে argument খিনি নোট করেছিল কি করবে জানো খালি সিম্পল এগুলো সব কাটিয়ে কিন্তু কাটি থোৱা কি কৰিব আকৌ argument শুনিব লাগিব What why do you नहीं तू सही नहीं सुन तो पेज है नहीं यहाँ पे असली मतलब ना खाली इसलिए कोड no काफी तो है वो सब काफी तो है 140 पेज सबके जाऊंटे सब बोल रहे
149 होता है भरेगा.
You didn't want me to go through the pages, that is why.
I'm so sorry.
Actually, it is very difficult for him now because आता है वो पहले तो पीछे पूरा पैसा
Again, I'll have to hear your argument, I think.
well that will be there like I miss having उसका होगा रहता है तो जब
If I don't get, then I'll hear the argument again.
My lord, no.
If I cannot find it. এই কিতাপখনৰ মাজত গুচি গ'ল নেকি?